And obviously, when Mr. Arar is the virtual focus of the inquiry, although it's about Canadian officials, we had to, and Justice O'Connor had to gain the legitimacy and credibility so that Mr. Arar and the other parties to the inquiry would gain confidence. Because, as I said, most of the hearings, or many of the hearings, were held in camera. And this was, of course, a public inquiry. Now, faced with this challenge, Justice O'Connor came up with a procedure which, although not perfect, had the confidence of Mr. Arar and his counsel, because in these secret hearings, there were independent counsel that were challenging throughout the government's evidence. So that even though Mr. Arar could not challenge the evidence himself, Commission counsel on behalf of Justice O'Connor thoroughly and vigorously tested all of the evidence which the government presented to the inquiry in camera. At the end of the day, once again, a tribute to Justice O'Connor, Mr. Arar had full confidence in the inquiry, and because he trusted Justice O'Connor because of his integrity, and he felt that even though he would not participate in the in-camera hearings, that Justice O'Connor would get to the bottom of the story, and as you know, he certainly did. Now, the reports from the final reports from the Arar inquiry deal with numerous important legal issues which touch upon our human rights, such as the role of government agencies in national security activities, the relationship that our agencies have with foreign agencies when they share information about Canadian citizens, torture, racial stereotyping. These are the issues that have been dealt with in the report. And let me say that the report, both reports from the Part 1 and 2 processes, have gained widespread support and respect around the world. The Americans are very interested in this report because of their past practices in respect of rendition and so on. The Europeans are very interested in the report because they have relied upon it in some of their legislative committees that are looking into some of the national security misconduct which has occurred in their countries as well. And finally, and most importantly, I think, I've been advised that the reports have been the topic of favorable and positive discussion in many Canadian mosques. And hopefully Justice O'Connor has gone a long way in helping to restore the trust and confidence which our Muslim communities have in Canadian government institutions. Now, these are achievements which most lawyers and judges can only dream of. Justice O'Connor's contributions to Canadian law, public policy, and human rights have been fundamental, and all Canadians will benefit from these achievements for years to come. In closing, let me say that Justice O'Connor has all of the qualities which make a great lawyer, a great judge, indeed a great public official. Qualities such as integrity, fairness, compassion, fearlessness, and humility. These are the characteristics which underlie all of his achievements and why Canadians hold Justice O'Connor in such high regard. Thank you.
I'd now like to call on His Honour Dennis O'Connor to come forward.
To be honored by an organization like this. It represents the association, really all of the values that I admire in Canadians. It obviously respects people of different views, political, cultural, social, religious. And those are the things that make Canada so great and really make me so proud to be a Canadian. And so to be honored by this group truly is an exceptional honor for me. Now tonight, and I've been asked to speak for, and it won't be too long, I can assure you, about public inquiries. I'm not going to talk about the two that I did, but public inquiries, as those who follow the media will realize, play an important role in Canada's public life. And what I will do tonight is give some of my observations, having been involved with two of them, about what I see some of the benefits and indeed a few of the problems. And I will also talk at the end about an issue that's becoming increasingly controversial, and that's whether sitting judges should act as commissioners of public inquiries, and I'll express my views on that. But let me start out by saying, historically, Canada has been a very heavy user of commissions of inquiry. Some of our very important public policies have emanated from public inquiries, and if anything, the use of public inquiries has increased in the last 10 years or so. By my count, there are currently underway or have reported within the last 3 years between 15 and 20 commissions of inquiry in Canada. And what's interesting about it is the broad range of subjects that these inquiries have covered. And let me just outline some of them. There's the national security inquiries, ARAR, Air India, which we'll report shortly, and the recently concluded investigation by retired Supreme Court of Canada Justice Yakabuchi into national security issues. Other topics have included wrongful convictions. There's been a number of those. But things like breast cancer testing in Newfoundland, child forensic pathology system in Ontario, Justice Gouge recently reported on, the child welfare system in Manitoba, remuneration of elected officials and municipal conflict of interest in Nova Scotia, First Nations standoff at Ipperwash, Aboriginal residential schools, SARS, meat inspection system. When you think about it, the number of public issues, and those are the ones that we've done recently, is really quite enormous as to what Canadian governments turn to the inquiry mechanism for. And in the not too distant past, we had the blood system, Canada's blood system. They had the interaction of development in northern Canada with Aboriginal interests, bank collapse, the drinking water system that I did, drugs and sports, and on it goes. I mean, if one looks back 15, 20, 25 years, really there's so many areas in the public interest that have been touched by this. And there's no doubt that we use this vehicle, public inquiries, more than any other of the Western democracies or any other country in the world. And before turning to some specific issues, let me just give a little background. They've been with us a long time. The origins of them are actually interesting. From the Middle Ages, the kings in England used to appoint royal commissions, they were then called. They're essentially the same as a public inquiry now is, to look into matters of concern and to give advice and report on public policy issues. Today, the federal government and most provinces have specific legislation, we do in Ontario, under which to establish public inquiries. They do it by way of order and council, and when they establish an inquiry, they typically give it compulsory powers so that they can compel the production of evidence, compel testimony, and investigate whatever the subject matter happens to be. And broadly put, there are two types of inquiries. There's the fact-finding inquiry. Typically something's gone wrong, there's been a scandal or some tragedy of some sort, and the public pressure is for the government to get to the bottom of it. And so that an inquiry, a commission of inquiry is appointed to look into the facts and to report what happened. Second, there's also, though, policy-based inquiries, where the commissions of inquiry are asked to make recommendations on issues of public interest in public policy.